Have you ever looked at a friend's answer script and thought, why didn't I think of that? Here's how you can brew your very own perfect argument. Hi, and welcome to the Law Simplified. I'm Shaveen Bandaranaike. As I have often impressed upon my fast track and masterclass students from all around the world, it's vital that as a law student, you develop over time your very own unique legal personality. A method by which your articulation, your arguments, your thinking is communicated to an examiner. And later on, when you enter the profession, to your opponents, to your colleagues, and judges as well. Now, it may be easier said than done, but it's actually through the arguments that you present in your answer scripts or later in your career, in your submissions, that actually hone and articulate you as a person, as a legal professional entering into the profession. That being said, this video is intended to show you quite briefly an example of how arguments can be incorporated into your answers, into the responses that you provide during an examination or a summative or a formative assignment submission. Now, mind you, this may be somewhat colored by the way that I often articulate responses or I argue when there's a scenario presented to me. But the goal here is to look at the contravening or the controversial positions that are presented to you, picking a side, and then presenting an argument that is not only unique to you, but interesting at that. Let's have a look by considering an examination question and then formulating our own unique argument. James had been sexually abused as a child and as a consequence still suffered from mild bouts of depression. One night, after spending a happy evening drinking heavily, he left his local pub with his workmate Vicky. As Vicky was too drunk to travel home, they decided to go to sleep it off at James's flat. James gave Vicky his bed and then went to sleep on a chair. In the middle of the night, James woke up and was startled to find Vicky kissing him and undoing the zip of his trousers. He pushed her away, but she would not stop and he became very angry. Intending serious harm, he grabbed her by the throat and hit her head against the wall. Vicky died. Consider James's possible criminal liability for Vicky's death. Now, this particular question relates to homicide in criminal law. If you are interested in learning more about the substantive components of homicide, as well as the way in which you can break down this question properly from A to Z and articulate a response, I'd highly recommend the online law school platform, which you can access through the links in the description below. But what we will be focusing on is a very specific area in this question in order to highlight the method by which you can present to an examiner an interesting argument, thereby your personality. Now, as you might see, this question relates to murder with the possibility of mitigating a charge of murder to voluntary manslaughter by either loss of self-control or diminished responsibility as per section 52, 54 and 55 of the Coroners and Justice Act of 2009. But what's most relevant to us and the argument that I'm trying to impress upon you is something slightly different. Now, whilst a question like this would invite us to discuss the primary offense, be it murder, as well as the partial defenses of voluntary manslaughter by loss of self-control and diminished responsibility, there is a further argument that you can bring about in order to indicate a third possibility apart from the partial defenses. I'd like you to focus on the very first paragraph in this question, specifically the concluding sentence of this paragraph. The fact that Vicky was too drunk to travel and they went to sleep it off at James's flat. Now note that murder and homicide in general, in terms of voluntary manslaughter as well, are specific intent offenses. Now, for those of you who might be uninitiated, briefly, a specific intent offense is one in which the prosecution must prove beyond reasonable doubt that the defendant intended the harm to the victim or the complainant. In other words, this was not by accident, this was something intentional or willful at the particular complainant or the victim. Now note that one possible defense to a specific intent offense is the presence of intoxication. Intoxication essentially means that the defendant might not have been capable of forming the necessary mens rea or the necessary intention in order for a specific intent crime to have been committed. The result of this is that any offense that a particular defendant is charged with, which is specific intent, is unsustainable by the prosecution. It is a doubt that you are creating as a defense counsel. Now, in this context, note how the facts of the matter relate to the notion that Vicky was too drunk to travel home, but mentions nothing about James. Now, why I'm pointing this out is because things which are there in a question are there for a reason. Things which are not there are also not there for a reason. Many students who attempt this particular question in my fast track and masterclasses often use intoxication as a possible defense to mitigate the specific intent nature of murder. But what's even more interesting is to not just identify the intoxication possibility, but also mention how they have distinguished in the question between the notion that Vicky is drunk but not James. Furthermore, the final line, which states James gave Vicky his bed and then went to sleep on a chair, indicates that James had the relevant foresight or the relevant state of mind to be able to make a rational decision. Now, this is only one example of how you might be able to brew up an argument, so to speak. In other words, try to articulate, based on the facts presented to you, a possible option that another student, or the examiner for that matter, might not anticipate from you. Right. This video was intended to give you a broad understanding of how important arguments are in developing your own legal personality. Brewing your very own arguments helps articulate and hone your very own skills, as well as showcasing to the recipient, be it an examiner when you're a student or a judge when you're a legal professional, who you are. And it helps you carve out your very own niche within the legal profession. Having said that, until the next time that we meet, have fun, stay safe, and as always, obey the law.